A. Subsection 1b does not affect an employer's obligations under I. The Official Information Act 1982, despite Section 52, 3, of that Act, or 2. The Privacy Act 1993, despite Section 7, 2, of that Act. B. An employer must not refuse to provide access to information under subsection 1a, c, merely because the information is contained in a document that includes confidential information. 1d, for the purposes of subsections 1b and 1c, confidential information means information that is provided in circumstances where there is a mutual understanding, whether express or implied, of secrecy. 2. The employment relationships are those between a. An employer and an employee employed by the employer. b. A union and an employer. c. A union and a member of the union. d. A union and another union that are parties bargaining for the same collective agreement. e. A union and another union that are parties to the same collective agreement. f. A union and a member of another union where both unions are bargaining for the same collective agreement. g. A union and a member of another union where both unions are parties to the same collective agreement. h. An employer and another employer where both employers are bargaining for the same collective agreement. 3. Subsection 1 does not prevent a party to an employment relationship communicating to another person a statement of fact or of opinion reasonably held about an employer's business or a union's affairs. 4. The duty of good faith in subsection 1 applies to the following matters. A. Bargaining for a collective agreement or for a variation of a collective agreement, including matters relating to the initiation of the bargaining. B. Any matter arising under or in relation to a collective agreement while the agreement is in force. B. Bargaining for an individual employment agreement or for a variation of an individual employment agreement. B. Any matter arising under or in relation to an individual employment agreement while the agreement is in force. C. Consultation, whether or not under a collective agreement, between an employer and its employees, including any union representing the reprinted as at January 1, 2018 Employment Relations Act 2000 Part 1 S. 4. 21. Employees, about the employees' collective employment interests, including the effect on employees of changes to the employer's business. D. A proposal by an employer that might impact on the employer's employees, including a proposal to contract out work otherwise done by the employees or to sell or transfer all or part of the employer's business. E. Making employees redundant. F. Access to a workplace by a representative of a union. G. Communications or contacts between a union and an employer relating to any secret ballots held for the purposes of bargaining for a collective agreement. 5. The matters specified in subsection 4 are examples and do not limit subsection 1. 6. It is a breach of subsection 1 for an employer to advise or to do anything with the intention of inducing an employee a. Not to be involved in bargaining for a collective agreement, or b. Not to be covered by a collective agreement. Section 4, 1a inserted, on December 1, 2004, by Section 5, 1, of the Employment Relations Amendment Act, No. 2, 2004, 2004 No. 86. Section 4, 1b replaced, on March 6, 2015, by Section 4 of the Employment Relations Amendment Act 2014, 2014 No. 61. Section 4, 1c replaced, on March 6, 2015, by Section 4 of the Employment Relations Amendment Act 2014, 2014 No. 61. Section 4, 1d inserted, on March 6, 2015, by Section 4 of the Employment Relations Amendment. Act 2014, 2014 Number 61. Section 4, 4(b)(a) inserted, on December 1, 2004, by Section 5, 2, of the Employment Relations Amendment Act, Number 2, 2004, 2004 Number 86. Section 4, 4(b)(b) inserted, on December 1, 2004, by Section 5, 2, of the Employment Relations Amendment Act, Number 2, 2004, 2004 Number 86. Section 4, 6 added, on December 1, 2004, by Section 5, 3, of the Employment Relations Amendment Act, Number 2, 2004, 2004 Number 86. 4(a) Penalty for certain breaches of duty of good faith. A party to an employment relationship who fails to comply with the duty of good faith in Section 4, 1, is liable to a penalty under this Act if a. the failure was deliberate, serious, and sustained, or b. the failure was intended to undermine I. bargaining for an individual employment agreement or a collective agreement, or 2. an individual employment agreement or a collective agreement, or 3. an employment relationship, or c. the failure was a breach of Section 59B or Section 59C. Part 1's 4(a) Employment Relations Act 2000. Reprinted as at January 1, 2018. 22. Section 4(a), inserted, on December 1, 2004, by Section 6 of the Employment Relations Amendment Act, Number 2, 2004, 2004 Number 86. Records relating to minimum entitlement provisions. Heading, inserted, on April 1, 2016, by Section 5 of the Employment Relations Amendment Act 2016. 2016 Number 9. 4(b) Employer's general obligation to keep records relating to minimum entitlement provisions. 1. An employer must keep records in sufficient detail to demonstrate that the employer has complied with minimum entitlement provisions. 2. The obligation in subsection 1 is in addition to the requirements in the other provisions of this Act or any other enactment relating to the keeping of records. Section 4(b), inserted, on April 1, 2016, by Section 5 of the Employment Relations Amendment Act 2016, 2016 Number 9. Part 2. Preliminary Provisions. Interpretation. 5. Interpretation. In this Act, unless the context otherwise requires, agreed hours of work means the hours of work specified in accordance with Section 67C, 1. Applicable collective agreement means the collective agreement that is binding on the relevant union and employer, at the relevant point in time in relation to an employee of the employer who is a member of the union. Authority means the employment relations authority established by Section 156. Bargaining, in relation to bargaining for a collective agreement. A. Means all the interactions between the parties to the bargaining that relate to the bargaining, and b. includes I. negotiations that relate to the bargaining, and 2. communications or correspondence, between or on behalf of the parties before, during, or after negotiations, that relate to the bargaining. Chief Executive means the Chief Executive of the department. Chief Judge means the Chief Judge of the court. Reprinted as at January 1, 2018 Employment Relations Act 2000 Part 2 S5. 23. Chief of the Authority means the Chief of the Authority who holds office under Section 166, 1(a). Collective agreement means an agreement that is binding on a. one or more unions, and b. 1 or more employers, and c. 2 or more employees. Compliance order means an order made by the authority or the court under Section 137 or Section 139. Court means the employment court constituted under this Act. Coverage clause. A. In relation to a collective agreement. I. Means a provision in the agreement that specifies the work that the agreement covers, whether by reference to the work or type of work or employees or types of employees, and 2. Includes a provision in the agreement that refers to named employees, or to the work or type of work done by named employees, to whom the collective agreement applies. B. In relation to a notice initiating bargaining for a collective agreement. Means a provision in the notice specifying the work that the agreement is intended to cover, whether by reference to the work or type of work or employees or types of employees. Demand notice means a demand notice issued under Section 224, 1. Department, in any provision of this Act, means the Department of State that, with the authority of the Prime Minister, is for the time being responsible for the administration of that provision. Dispute means a dispute about the interpretation, application, or operation of an employment agreement. Dwelling house. A. Means any building or any part of a building to the extent that it is occupied as a residence, and b. In relation to a home worker who works in a building that is not wholly occupied as a residence, excludes any part of the building not occupied as a residence. Employee is defined in Section 6. Employer means a person employing any employee or employees, and includes a person engaging or employing a home worker. Employment agreement. A. Means a contract of service, and Part 2 S5 Employment Relations Act 2000. Reprinted as at January 1, 2018. 24. B. Includes a contract for services between an employer and a home worker. And c. Includes an employee's terms and conditions of employment in I. A collective agreement, or 2. A collective agreement together with any additional terms and conditions of employment, or 3. An individual employment agreement. Employment relationship means any of the employment relationships specified in Section 4, 2. Employment relationship problem includes a personal grievance, a dispute, and any other problem relating to or arising out of an employment relationship, but does not include any problem with the fixing of new terms and conditions of employment. Employment standards means any of the following. A. The requirements of any of Sections 64, 69Y, 69ZD, 69ZE, and 130. B. The provisions of the Equal Pay Act 1972. C. The minimum entitlements and payment for those under the Holidays Act 2003. D. The requirements of Sections 81 and 82 of the Holidays Act 2003. E. The minimum entitlements under the Minimum Wage Act 1983. F. The provisions of the Wages Protection Act 1983. Essential service means a service specified in Schedule 1. Home worker. A. Means a person who is engaged, employed, or contracted by any other person, in the course of that other person's trade or business, to do work for that other person in a dwelling house, not being work on that dwelling house or fixtures, fittings, or furniture in it, and b. Includes a person who is in substance so engaged, employed, or contracted even though the form of the contract between the parties is technically that of vendor and purchaser. Individual employment agreement means an employment agreement entered into by one employer and one employee who is not bound by a collective agreement that binds the employer. Intended agreement includes part of an intended agreement. Judge means a judge of the court, and includes an acting judge. Labor inspector means an employee of the department designated under Section 223 to be a labor inspector. Reprinted as at January 1, 2018 Employment Relations Act 2000 Part 2 S5. 25. Lawyer has the meaning given to it by Section 6 of the Lawyers and Conveyancers Act 2006. Lockout has the meaning given to it by Section 82. Mediation includes mediation services provided under Section 144 by the Chief Executive, and any other mediation services that are provided, whether by the Chief Executive or any other person, to help resolve employment relationship problems. Mediation services means the mediation services provided, under Section 144, by the Chief Executive. Member of the authority means a member of the authority who holds office under Section 166, 1, and includes a temporary member who holds office under Section 172. Minimum entitlement provisions means a. The minimum entitlements and payment for those under the Holidays Act 2003, and b. The minimum entitlements under the Minimum Wage Act 1983, and c. The provisions of the Wages Protection Act 1983. Minister, in any provision of this Act, means the Minister of the Crown who, under the authority of any warrant or with the authority of the Prime Minister, is for the time being responsible for the administration of that provision. Person intending to work means a person who has been offered, and accepted, work as an employee, and intended work has a corresponding meaning. Personal grievance or grievance has the meaning given to it by Section 103. Prescribed means prescribed by regulations made under this Act. Registrar of the Court means any employee of the department designated under Section 198 to act as the Registrar of the Court. Registrar of Unions means the employee of the department appointed under Section 27 to be the Registrar of Unions. Relevant Acts. A. In Sections 223A and 223B, means the acts specified in Section 223, 1. Except Section 69LA of this Act. B. In Sections 223D to 223F, means the acts specified in Section 223, 1. Except Part 5 and Section 69LA of this Act. Strike has the meaning given to it by Section 81. Union means a union registered under Part 4. Wages and time record means a wages and time record kept pursuant to Section 130. Part 2 S5 Employment Relations Act 2000. Reprinted as at January 1, 2018. 26. Workplace means a place where an employee works from time to time, and includes a place where an employee goes to do work. Section 5 Agreed hours of work, inserted, on April 1, 2016, by Section 6, 1, of the Employment Relations Amendment Act 2016, 2016 No. 9. Section 5 Coverage Clause Paragraph, A substituted, on December 1, 2004, by Section 7, 1, of the Employment Relations Amendment Act, No. 2, 2004, 2004 No. 86. Section 5 Dwelling House, substituted, on December 1, 2004, by Section 7, 2, of the Employment Relations Amendment Act, No. 2, 2004, 2004 No. 86. Section 5 Employment Standards, inserted, on April 1, 2016, by Section 6, 1, of the Employment Relations Amendment Act 2016, 2016 No. 9. Section 5 Homeworker Paragraph, be amended, on December 1, 2004, by Section 7, 3, of the Employment Relations Amendment Act, No. 2, 2004, 2004 No. 86. Section 5 Intended Agreement, inserted, on April 1, 2011, by Section 4 of the Employment Relations Amendment Act 2010, 2010 No. 125. Section 5 Judge, amended, on March 1, 2017, by Section 4, 1, of the Employment Relations Amendment Act, No. 2, 2016, 2016 No. 62. Section 5 Lawyer, inserted, on March 1, 2017, by Section 4, 2, of the Employment Relations Amendment Act, No. 2, 2016, 2016 No. 62. Section 5 Minimum Entitlement Provisions, inserted, on April 1, 2016, by Section 6, 2, of the Employment Relations Amendment Act 2016, 2016 No. 9. Section 5 Minimum Entitlements, repealed, on April 1, 2016, by Section 6, 2, of the Employment Relations Amendment Act 2016, 2016 No. 9. Section 5 Relevant Acts, replaced, on March 6, 2015, by Section 5 of the Employment Relations Amendment Act 2014, 2014 No. 61. 5A Provisions affecting application of amendments to this Act. Schedule 1A contains application, savings, and transitional provisions relating to amendments made to this Act after January 1, 2013, see Section 254. Section 5A, inserted, on March 6, 2015, by Section 6 of the Employment Relations Amendment Act 2014, 2014 No. 61. 6 Meaning of employee. 1. In this Act, unless the context otherwise requires, employee a. means any person of any age employed by an employer to do any work for hire or reward under a contract of service, and b. includes I. a home worker, or 2. a person intending to work, but c. excludes a volunteer who I. does not expect to be rewarded for work to be performed as a volunteer, and 2. receives no reward for work performed as a volunteer, and d. excludes, in relation to a film production, any of the following persons. Reprinted as at January 1, 2018 Employment Relations Act 2000 Part 2 S6. 27. I. a person engaged in film production work as an actor, voice-over actor, stand-in, body double, stunt performer, extra, singer, musician, dancer, or entertainer. 2. A person engaged in film production work in any other capacity. 1a, however, subsection 1d, does not apply if the person is a party to, or covered by, a written employment agreement that provides that the person is an employee. 2. In deciding for the purposes of subsection 1a, whether a person is employed by another person under a contract of service, the court, or the authority, as the case may be, must determine the real nature of the relationship between them. 3. For the purposes of subsection 2, the court or the authority a. must consider all relevant matters, including any matters that indicate the intention of the persons, and b. is not to treat as a determining matter any statement by the persons that describes the nature of their relationship. 4. Subsections 2 and 3 do not limit or affect the Real Estate Agents Act 2008 or the Share Milking Agreements Act 1937. 5. The court may, on the application of a union, a labor inspector, or one or more other persons, by order declare whether the person or persons named in the application are a. employees under this Act, or b. employees or workers within the meaning of any of the acts specified in Section 223, 1. 6. The court must not make an order under subsection 5, in relation to a person, unless a. the person I. is the applicant, or 2. has consented in writing to another person applying for the order, and b. The other person who is alleged to be the employer of the person is a party to the application or has an opportunity to be heard on the application. 7. In this section, film means a cinematograph film, a video recording, and any other material record of visual moving images that is capable of being used for the subsequent display of those images, and includes any part of any film, and any copy or part of a copy of the whole or any part of a film. Film production means the production of a film or video game. Film production work. Part 2 S6 Employment Relations Act 2000. Reprinted as at January 1, 2018. 28. A. Means the following work performed, or services provided, in relation to a film production. I. Work performed, or services provided, by an actor, voice-over actor, stand-in, body double, stunt performer, extra, singer, musician, dancer, or entertainer, whether as an individual or not. 2. Pre-production work or services, whether on the set or off the set. 3. Production work or services, whether on the set or off the set. 4. Post-production work or services, whether on the set or off the set. V. Promotional or advertising work or services, whether on the set or off the set, by a person referred to in subparagraphs I, 2, 4, but B. Excludes work performed, or services provided, in respect of the production of any program intended initially for broadcast on television. Video game means any video recording that is designed for use wholly or principally as a game. Video recording means any disc, magnetic tape, or solid-state recording device containing information by the use of which one or more series of visual images may be produced electronically and shown as a moving picture. Section 6, 1, D added, on October 30, 2010, by Section 4, 1, of the Employment Relations, Film Production Work, Amendment Act 2010, 2010 number 120. Section 6, 1A inserted, on October 30, 2010, by Section 4, 2, of the Employment Relations, Film Production Work, Amendment Act 2010, 2010 number 120. Section 6, 4 amended, on November 16, 2009, by Section 173 of the Real Estate Agents Act 2008. 2008 number 66. Section 6, 7 added, on October 30, 2010, by Section 4, 3, of the Employment Relations, Film Production Work, Amendment Act 2010, 2010 number 120. 6A Status of Examples. 1. In this Act, an example is only illustrative of the provision it relates to and does not limit the provision. 2. If an example and the provision it relates to are inconsistent, the provision prevails. 3. In this section, example includes any note that relates to the example. Section 6A, inserted, on September 14, 2006, by Section 5 of the Employment Relations Amendment Act 2006, 2006 number 41. Part 3. Freedom of Association. 7 Object of this part. The object of this part is to establish that, reprinted as at January 1, 2018 Employment Relations Act 2000 Part 3 S7. 29. A. Employees have the freedom to choose whether or not to form a union or be members of a union for the purpose of advancing their collective employment interests, and b. No person may, in relation to employment issues, confer any preference or apply any undue influence, directly or indirectly, on another person, because the other person is or is not a member of a union. Compare 1991 number 22 S5. 8. Voluntary membership of unions. A contract, agreement, or other arrangement between persons must not require a person a. to become or remain a member of a union or a particular union, or b. to cease to be a member of a union or a particular union, or c. not to become a member of a union or a particular union. Compare 1991 number 22s6. 9. Prohibition on preference. 1. A contract, agreement, or other arrangement between persons must not confer on a person, because the person is or is not a member of a union or a particular union. A. Any preference in obtaining or retaining employment, or b. Any preference in relation to terms or conditions of employment, including conditions relating to redundancy, or fringe benefits or opportunities for training, promotion, or transfer. 2. Subsection 1. Is not breached simply because an employee's employment agreement or terms and conditions of employment are different from those of another employee employed by the same employer. 3. To avoid doubt, this act does not prevent a collective agreement containing a term or condition that is intended to recognize the benefits a. of a collective agreement, b. arising out of the relationship on which a collective agreement is based. Compare 1991 number 22s7. Section 9, 3 added, on December 1, 2004, by Section 8 of the Employment Relations Amendment Act, number 2, 2004, 2004 number 86. 10. Contracts, agreements, or other arrangements inconsistent with Section 8 or Section 9. A contract, agreement, or other arrangement has no force or effect to the extent that it is inconsistent with Section 8 or Section 9.